request to record that's been filed, is that correct?
Pardon me?
There's a request to record that's been filed. Is there someone in the courtroom recording? Have you filed, I can't read the name of the person filing the request.
Is your take pictures for the newspaper? That's a request.
All right, and what's the newspaper?
El Informador, the Spanish newspaper in Grand Rapids.
All right. You're going to take still photos? Is that what you're going to do?
Yes, ma'am.
Okay. That's fine. I don't have any objection to that. Does anyone have an objection? Pardon me? Yes, that's fine.
Okay, thank you.
Does anyone have, I should ask perhaps, does anyone have any objection?
I have no objection.
I have no objection to that, and you may do that.
Thank you.
Thank you. All right, the court had a request by the plaintiff in the Brunger versus Robbins case regarding the issue of enforcing a settlement agreement. The court is aware that there's two other cases, so that although it's not clear at this point in time to the court whether or not these cases can be combined or not, and that's really why we're here, why the court called this hearing, because at this point in time it appears that there is several issues of fact that I'm not sure I understand completely. And in reading the complaints in the newer files, I don't know if the alleged damage to property that Mr. Ortman's claiming against Mr. Brunger is related to the same bit of property, or if it's a different issue. It's unclear to me. I don't know. But obviously, if it is, these cases should be joined in the court's opinion. Also, when this settlement was entered into, the court was of the impression that Mr. Robbins had the right to enter into the settlement agreement, and everything that's been presented to the court since that time has suggested that Mr. Robbins didn't have the right to enter into the settlement agreement because he's not the owner of the property, which presents obviously a significant concern to the court about the status of being able to enforce an agreement that essentially is unenforceable because not all the parties to the property are involved in the agreement. So I would like to have the parties address the court's concerns at this time. Mr. Zessin?
Well, I brought this matter to the attention of the court in the form of a motion, and that motion was filed with the court on the 11th. It's a motion for contempt, enforcement of orders, sanctions, and reimbursement of fees. The court has been very clear in its direction in this case that it was going to order Mr. Robbins, pursuant to the terms of the agreement that was placed on the record that he acknowledged in court with counsel that he had the authority to do. And that was to make corrections to his property to alleviate the nuisance that he admitted that he created when he dug a pond and put all the spoils on the property adjacent to Mr. Brunger's, essentially damming up what used to be the natural flow of stormwater from one direction to another direction. We've covered this ground over and over and over again. The court made its clear determination that there was an August 9th, 2012 engineering study done by Latitude Engineering which said we have to prepare a swale. And the swale is to evacuate water that normally would go in one direction off into the blueberry fields. So this was acknowledged by Mr. Robbins, signed a settlement agreement, said he would do that. He afterwards changed his mind and decided he didn't want to do that, so then the court had to become involved in enforcing the order. The court said that that Mr. Brunger and his excavator would be permitted on the property to complete the swale, that Mr. Bexford would be allowed to go onto the property and and approve what the engineering study said needed to be done in order to construct the swale. We made arrangements for our excavator, which is RP Excavation and Septic, to go out on the property on October 10th. I informed Mr. Alvarez that this would be the case. And I informed him by phone on the 8th that we'd be doing this and that Mr. Bexford would be with him. At that time, Mr. Alvarez told me that there was a swale that had been constructed on the property by somebody other than RP Septic. This is important because the court, in its order of September 11th, 2013, said Mr. Robbins was to provide a proof of license that his engineer or his proposed excavator would be licensed, and that the court would then choose between the excavator chosen or submitted by Mr. Brunger and the excavator selected by Mr. Robbins. Mr. Robbins never bothered to send the court a copy of the license, requiring the court to go to the extra work then of deciding that and entering an order specifically that said that RP Septic and Excavating could go on the property and they were the one assigned to complete the work pursuant to the October 15th, 2012 order, which said we need to construct the swale consistent with the Bexford study, or the latitude engineering study, of August 9th, 2012. So he didn't bother to submit a license. The court entered an order. We made arrangements for it to go on, and Mr. Alvarez says to me on the phone, okay, we've already dug the swale. You're not coming on the property. Mr. Bexford's not coming on the property. I immediately called the court and said, what do we do? We've got an order that says specifically what's supposed to happen. At that point, you ordered that Mr. Bexford would go onto the property on October 10th. On October 10th, he went onto the property, determined that there was no compliance with the court's order in terms of the excavation. All this time, we're operating under the assumption that the orders of the court have to be followed. There's never a concern about whether we can go on or whether we can't go on. It's been determined through denying of motions for summary disposition that that Mr. Robbins had the ability to manage and control the events that took place on the property, that he was the one that caused the nuisance, and he was the one that would be ordered to alleviate the nuisance. There was a motion for summary disposition in the September 11th, 2013 order specifically directs or specifically addresses the issue that you raised in your opening comments. That summary disposition motion was based upon the fact that Mr. Robbins claimed, I don't own the property, and therefore you can't tell me that I have to do anything because I really don't have the ability to effectuate any change on the property. So we crossed that bridge before. The arguments were on August 26, 2013. The order was on September 11th, 2013. You said he has the ability, he's going to be held to these orders. So I'm not sure why there's a concern now as to whether or not the court can order him to do certain things. You have crossed that bridge, you've made that order, you denied a motion for summary disposition that alleged specifically that couldn't happen. So in our phone conversation, Judge, on the 9th, you said Mr. Bexford is going to go out there, he's going to take a look at it. If there's not compliance with the order, Mr. Robbins is going to be sanctioned, and RP is going to go out there and dig the swale the way the August 9th, 2012 engineering report said it was going to be done. And we're going to do it this week. Instead, I get a notification that I have to file a motion, that I have to have a hearing, that we have to make some other determination as to whether or not I guess he should be sanctioned, or what we're going to do next, but we just keep retreading the same territory over and over and over again because of Mr. Robbins' repeated defiance of the court's order. Not only does he sit on the stand and defy the court's order, by his behavior, he continues to defy the court's order. So I'm asking for sanctions. I'm asking that RP be ordered, contrary to whatever Mr. Robbins might choose he doesn't want to do, to go and complete the work, the swale, construct the swale in accordance with the engineering study of August 9th, 2013, that Mr. Becksford be allowed to go onto the property and make a determination as to whether or not RP has constructed the swale correctly, and that we finally enforce the orders of this court, that Mr. Becksford be compensated for his time. He said to write 2 letters. He said to make a special trip out on October 10th. He wrote a letter on October 10th that I sent to the court saying there's no compliance. I submitted a subsequent report with more detail on October 14th, that he wrote for October 14th, 2013. Sent copies to you and Mr. Alvarez saying that the swale isn't constructed properly, the elevations are not restored to their historical levels, that water does not flow into the swale, that water does not flow out of the swale because of the way that it's designed and because it was constructed improperly. We're just asking that it be done properly. Mr. Robbins took it upon himself to have somebody else besides RP construct a swale. And the risk that he takes when he defies the orders and does things his own way is that he has to come back to court and explain why it doesn't comply with the court's order. And in doing so, he wastes your time and my time and Mr. Becksford's time and my client's time. And for that, he needs to be sanctioned. He needs to be held in contempt of court. And you need to give him specific direction as to what's going to happen next because he doesn't seem to get it. Thank you.
Well, Mr. Zesman, can you explain to me why you didn't join Mr. Ortman into this lawsuit?
I never was aware that he was the owner of the property to begin with. Number 2, Mr. Robbins is the person who dug the pond and created the nuisance and was in control and managed the entire process. Mr. Robbins hired Mr. Johnson to represent him in the case. Mr. Robbins came to court with Mr. Johnson all the time and not Mr. Ortman.
I understand all that. I understand all that. That's not my... At this point in time, it appears to be some dispute that court doesn't have any proof of who owns this property. I have no proof of that at this point in time.
You don't need to have proof of who owns it.
Well, I think I do because they're claiming that Mr. Robbins doesn't own the property and that we're, in fact, making orders, and no one's giving me any proof. It's amazing to me that we've gotten this far in this lawsuit and no one wants to provide me with proof of ownership. And Mr. Ortman allegedly was here for all these hearings and never advised the court he owned the property or provided the court with any proof of owning the property. I'm not sure what his tactic was in regards to that. And I don't disagree that Mr. Robbins entered into an agreement and didn't fulfill the court's order. I don't disagree with that a bit, and I don't understand that either. But nonetheless, if this property, if this dirt belongs to Mr. Ortman, then Mr. Ortman should be a part of this lawsuit.
When you ruled on the motion for summary disposition,
I understand that.
You were cited law that said that a person who creates the nuisance or controls the process by which the nuisance was created is the person who is responsible for abating the nuisance and the person against whom the court can enter orders.
And
that was August 20.
I did enter orders against him.
August 26, 2013
I
argument.
understand that, Mr. Zesson. So we're going to have these subsequent lawsuits, and I don't understand if Mr. Ortman's lawsuit against your client is in regards to that or if that's some other issue.
Well,
I don't know that. And if it is the same issue, then they should be joined. Does that alleviate the issue in regards to Mr. Robbins for Mr. Robbins? No, I don't think it does. But I still think we've got an issue in regards to what to do about Mr. Ortman's interest in this property.
He rented the property, apparently, according to Mr. Robbins' testimony, to him. If Mr. Robbins is violating their lease arrangement in some way, Mr. Ortman has civil remedies against Mr. Robbins in the form of violation of the lease, a complaint for damages, something that's happened to the property that's been caused by Mr. Robbins. That's a right that Mr. Ortman has.
He does. You're right. He does.
And so if Mr. Ortman has been damaged by something Mr. Robbins did, which the court has found that he did wrong, and which he acknowledged that he did wrong by creating the nuisance and telling the court, I'll settle the case by agreeing to abate the nuisance. If Mr. Ortman has been damaged by something Mr. Robbins has done, then Mr. Ortman should come to this court and claim the damages that he's incurred civilly because of his behavior.
I understand.
He has a full record here that says everything that Mr. Robbins did, and Mr. Robbins' acknowledgement on 3 different occasions that I created a nuisance, I will abate the nuisance. Mr. Ortman never said, hey, this is costing me money, I've been damaged, my property is hurt, my property is reconfigured, whatever. He never came to court, but he has a separate civil remedy for that if his property has been damaged by his tenant.
But it's mine. All right. Response, Mr. Alvarez?
Several, Your Honor.
Number one, Your Honor, I would like to point out that
Is Mr. Ortman here?
he is not. He is ill today, so he's not in court today. He has an MRI CAT scan scheduled tomorrow, I believe, and though he did want to be here, he was not able to make it today. Your Honor, I would like to point out that I've reviewed the video, the audio of the hearings that were held here, specifically September 24th, when the agreement was entered into on the record. And there was never any admission by Mr. Robbins or never any questions asked where he would have admitted that he created this nuisance. The reason that this agreement or this order came to be was a backroom deal entered into by Mr. Robbins' previous counsel and plaintiff's counsel to try and alleviate this simple, what it appeared to be at the time, a simple property dispute between neighbors, and try and deal with it efficiently and with as little litigation cost as possible.
Mr. Alvarez, let's back up a minute.
Sure.
We had a signed stipulation in order by this court. How is that a backroom deal?
What I'm saying, Your Honor, is that
that's
the
a
defense...
very inappropriate way to present what is obviously a court order in regards to a stipulation the parties entered into.
Poor choice of words, Your Honor.
Yeah,
if I may
it is
clarify.
a poor choice of words.
If I may clarify, what I'm saying, Your Honor, is that instead of raising the proper defenses to the claims made, because the complaint itself characterized Mr. Robbins as the owner of the property, a simple title search, even on the Allegan County website itself, clearly shows that Mr. Robbins is not the owner of the property. What I'm saying is that those defenses, any defenses that Mr. Robbins could have raised at that point, were put aside in an effort to try and be done with this case, which at the time seemed like a simple dispute that could be handled with the building of a swale, a ditch, whatever. Now, one of the main issues that we have here, and the reason why this case is blown up like it has, is because Mr. Robbins did attempt, and I know we've gone through this before, but I want to make it known for the record, Mr. Robbins did attempt to build what he believed at the time would resolve
You have
the
a
issue.
record on that, and the court determined it wasn't
Correct.
a swale consistent with the agreement that the parties entered into.
Correct.
You don't have to make a new record on that. It's pretty clear, and the court's very well aware of what the record said previously in regards to the show cause hearing we had, where I determined that your client was in contempt of court for violating the order.
That is correct, Your Honor. My point was that from October 15th, when this order was entered, and by the time when that ditch had been built or constructed, until May, when the first motion to file contempt charge against Mr. Robbins was filed, there was nothing that happened in the case. There was no contact between Mr. Bexford returning calls to Mr. Robbins. There was no filings of any pleadings arguing that he was in contempt for 8 months, Your Honor, is what I'm saying. When we finally entered into this case, when I finally entered into this case in May, was for the contempt hearing. And once I found out that Mr. Robbins was not the property owner, I brought it to the court's attention through a motion to reconsider, which I believe is still pending before the court. And we've been on that basis and hitting that fact since then. Now, as far as who created the nuisance, Your Honor, we have filed with the court a copy of the permit that was pulled for the construction of the pond. It was pulled by Mr. Ortman, okay?
Is
There
there
has
proof
been-
that he owns the property?
No, Your Honor, that's proof that he's the one that at least controlled or constructed the pond at issue here. There has been no testimony, there has been no admissions by Mr. Robbins that he created any of this. I believe that there was mention of a photo of Mr. Robbins on a tractor, and that's great if we could see that once this litigation gets going. But right now, we do have the very issue that Mr. Ortman is the landowner. There is no lease, there is no rental agreement. Mr. Robbins is in fact living on the property just to help at the goodwill of Mr. Ortman. There is no land contract, there is no lease, there's no rental agreement. Mr. Ortman is allowing him to live there because he had some issues before, some personal financial issues, and is allowing him to live there while he manages his limo company, Mr. Ortman's limo company. So the issue of what rights Mr. Robbins has on the property are something also that will have to be litigated, but there is nothing that has been brought to the court thus far, as the court correctly points out, as to who actually has authority to do anything on this property. For the court to order excavation on property that is in a case where the landowner is not a party in interest or has not been joined as a necessary party is, in my opinion, I just don't see how it can happen, Your Honor.
Well, how can it happen that your client makes 2 attempts to allegedly comply with the settlement agreement by having this unapproved excavator come in and do the work and completely ignoring the court orders, but that's okay?
Your Honor, and with regard to that,
Is
and I
that
did
okay?
mention, Your Honor, if I may.
No, I need an answer.
Your Honor, if I can respond, I will let you know, as I did Mr. Zessin, as I let the court know on October 9th. It was not Mr. Robbins who ordered the construction of the swell. It was
Did
Mr.
you
Ortman.
provide the court with a certification of a license or certification in regards to the excavator you wanted to use as the court ordered you to do?
No, we did not, Your Honor. And the reason for that is I
So-
discovered.
That's my point. In this particular case, no one wants to listen to the court. And I don't know even why you're bothering coming to court if you're going to ignore everything the court orders.
Your Honor, there was nothing for us to turn in. We discovered after the fact that the license that we believe Mr. Hassing had there was no license, as Mr. Zessin did state on the record that day. He did not have a license for excavation as indicated. What he had was what he felt was a license was nothing more than a registration for doing business in the county of Allegan. That was not a licensed, he is not a licensed excavator, and there was therefore nothing to turn in at that point.
So you knew there was work done. You alleged that, my understanding is that that work had been approved by Mr. Bexford in the phone conversation that I had with you and Mr. Zessin. Correct?
I stated, Your Honor, that Holland Engineering contacted Mr. Bexford to get information from him to get the data and whatever background information they needed to confirm the numbers on the swale, which is exactly what they told me they did. Because the report from Latitude Engineering that Mr. Bexford created was missing many data, had inaccuracies and inconsistencies, including a 100-foot difference between the low elevation of the house and the low elevation of the barn, which by eyesight you can tell there is no 100-foot difference. So what I said was, Holland Engineering contacted Mr. Bexford, let him know what was happening, and asked for information so that Holland Engineering could come out and run a survey, which they did, to certify the swale to see if it met with Mr. Bexford's recommendations, which they did.
Anything further?
Nothing, Your Honor.
And you are?
I'm sorry, Your Honor. My name is Joshua Margret. I'm here on behalf of Mr. Robbins. So I have an appearance here, Your Honor, if I could approach with it.
You may. Could you give us your bar number?
Sure. Would you like it yourself now?
That, oh, you can hear me, too. This line, thank you.
P number 74897.
Thank you. And you're representing Mr.
Mr. Robbins as well, Your Honor, yes. I just recently submitted to this court.
In which file?
In the principal file, Your Honor, the
Brunger v. Robbins.
The Brunger v. Robbins, yeah, the case number that's on the appearance. I submitted a motion to stay the effect of the September 11th order. I'm the one at our firm that's responsible for dealing with appeals and similar issues.
I don't remember. Oh, when did you submit that?
Just yesterday, or actually just this morning, Your Honor, excuse me. I'll be happy to answer any questions the court has about it as well.
Well, since I just received it and haven't had a chance to read it, I'm not going to have any questions
Of
for
course,
you.
Your Honor.
Did you provide Mr. Zessen with a copy?
We put it in the mail yesterday, Your Honor, yes.
You haven't received it, Mr. Zessen, I presume?
Of course not.
Is the litigation in the file of Ortman, Mr. Brunger, relating to this same property issue, or is it a different property issue?
Same property issue, Your Honor.
Your Honor, I would agree. There are different claims with regard to Mr. Brunger having built or constructed a berm along the property, which is affecting both properties. We would have no objection to the consolidation of those two cases.
You filed a motion for consolidation?
I did. With my response to the complaint that Mr. Ortman filed, which I think has been assigned to Judge Cronin.
Which file? The one
The Ortman v. Brunger,
was assigned to Judge Cronin?
I
No.
believe.
I believe it was transferred to your...
It's assigned to me.
It's now assigned to you.
Well-
Okay.
It always was assigned to me.
Okay. But anyways, I think there are common questions of fact and law that need to be.
So those are consolidated. What about the Robbins versus Brunger matter?
I don't think those involve
Correct.
I
similar.
understand they're not.
But they are.
In relation to. My question is, it appears that their allegations of harassment or stalking are related to this entire lawsuit, but if they're not, I guess we can't include that in the overall scheme of things. What's the party's position on that?
Your Honor, our position is that some of these events occurred prior to the beginning of this litigation, and so we believe that they are not related to the property dispute.
Right. Well, then we won't join that one. But the other two are going to be joined. In regards to the overall case, the court's concerned about containing what appears to be unnecessary litigation in this case, but on the other hand also feels that there are issues that are not resolved from a legal standpoint regarding Mr. Ortman's involvement. However, I want to keep on track because I do believe that Mr. Robbins either with the acquiescence of Mr. Ortman or aware of what Mr. Ortman was doing, to a certain extent, once again, ignored what the court was trying to do in its previous orders, and very concerned about the ability of the court to address this situation in a manner which would result in everyone understanding what the court expects to happen and when it expects to happen. The fact that there was no certification, I would have presumed that then counsel for Mr. Robbins would have let me know that they were not certified and let me know that. But I didn't put it in the order, and by the way, let me know if they're not certified, because I didn't think that was necessary. I thought counsel would let me know that and not let it sit out there, let it drag on, and in essence know that the court was issuing an order that in essence could not be upheld to a certain extent because there had been further work on the property done. And to not inform the court of that, considering the level of litigation and animosity in this case, I find somewhat astounding and disturbing that I have to be so particular in the orders that I issue that I have to advise counsel to tell the court specifically yes or specifically no on an issue. I don't know how long into the winter we can go with a situation without it being impossible for excavation to occur. I'm not familiar enough with what excavators do and when they can do it and how they can do it. I am going to set this for further hearing within a short period of time. Mr. Zessin just received, or hasn't received, excuse me, the necessary pleadings, since they were just mailed to him yesterday. Mr. Zessin will be allowed to respond to those pleadings. I'd like to make it very clear that the court expects no other pleadings on this matter until the current ones are resolved. The court would also order Mr. Ortman and Mr. Robbins and Mr. Brunger to not make any further changes to the property in any way until this issue is resolved. Court's anticipation is that there will be a properly constructed swale at some point in time, hopefully sooner rather than later, in a way that will alleviate the pond damage or the damage to Mr. Brunger's property that, in the court's review of the file, Mr. Robbins, through his stipulation, acknowledged existed. We're looking at November 6th at 2:30.
Sorry, Your Honor, if I might, are you thinking of hearing particularly on that date the motion to stay? Or could you just summarize for our benefit?
All of the pending motions will be resolved that day. Mr. Zessin is given an opportunity to respond to the motion to stay. The court will not entertain any other motions that day other than the ones that are pending. Mr. Zessin has his pending in regards to sanctions and completing the work. You have your motion to stay. The cases are consolidated at this time.
Yeah, does that include the motion to reconsider that's currently pending before the court?
There's no hearing on the motion for reconsideration.
The court is not going to hear arguments on the motion to reconsider.
Thank you.
Can you advise Chris to set that date, please?
You said November 6th at 2:30?
Yes. No, the next hearing's at 4, so it should be for that time frame. We're adjourned.
What's the 28th?
Thank you, Your Honor.